Hello, everyone. My name is Giovanni Nogales, and I am a paralegal here at Laos Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Reading the Tea Leaves. What are the top 10 risks your home health agency and hospice will face in 2026? Our presenters for today are Michael Tobin and Lester Johnson. Michael Tobin practices in healthcare regulatory compliance. Michael attended Stetson University College of Law, where he graduated cum laude with a concentration in business. In law school, Michael maintained leadership positions with the Stetson Business Law Review. Michael is also an active member of the Sports Lawyer Association. As for Lester Johnson, is a partner at Laos Parker and is a supervising attorney for the firm's Baton Rouge office. In addition, thank you. Les also serves as the co-leader of the firm's health law practice group. Les helped clients navigate the myriad of regulatory compliance and business issues facing today's healthcare providers and practitioners. Core areas of Les practices include handling Medicare and Medicaid appeals and Medicare and Medicaid participation and compliance. If you have any questions throughout the presentation, please feel free to type them in the question box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you Michael Tobin and Lester Johnson.
All right. Thank you very much for that, Gio. And thank you, everyone, for taking some time to come and listen to us today on one of the last days of the year. We'll get right into it with a quote, I believe, here. First off, just a little disclaimer. This whole slideshow is not intended to be legal advice per se. Best case is to go to healthcare attorneys for specific needs, but we're giving more of a general overview today. So without further ado, let's start with a quote here by Supreme Court Justice Gorsuch, which kind of envelops a lot of what we'll be talking about today. And so we just want to start with it. And he said, criminal laws have grown so exuberantly and come to cover so much previously innocent conduct that almost anyone can be arrested for something. And that is certainly what we're going to see as we go through these slides today. It's just a web of laws that have been created and a lot of contractors, government bodies that can crack down on you, and that's what we've seen lately. So we'll head to the next slide, Gio, now, and look at some of those parties, some of that web of contractors, the current enforcement environment. And we won't discuss all of these here right now. We'll get to a lot of them throughout this presentation. But this is just an overview that kind of shows you how many parties are actually at play here. All federal contract auditors and private payer auditors up in this web here. Some of the main ones that we see a lot of, the Unified Program Integrity Contractors, UPICs, those are all over the place. The Medicaid Fraud Control Units, the MFOCUs, those are very relevant as well. And of course, the Medicare Administrative Contractors, the MACs, those are going to be, all throughout the country also. And all of these parties are going to be relevant, maybe not to your practice all at the same time, at one time or another, but I would not be surprised with crackdowns on fraud if you see one of these parties contacting you. We hope not, but that's what we do. We work with compliance here. Next slide, Jill. Thank you. All right, so an enforcement overview here, just in general, from September 15th, 2022, the former Deputy Attorney General, Lisa Monaco, issued a statement here, but it does hold true today, and we will go through and read that. She had previous guidance in 2021, and she reiterated this, that the department's first priority in corporate criminal matters is to hold accountable the individuals who commit and profit from corporate crime. And I said she's the former Deputy Attorney General, but that what she says, her words still hold true today, even more cracking down on corporate crime, making sure that individuals do not profit corporations can best deter misconduct if they make clear that all individuals who engage in or contribute to criminal misconduct will be held personally accountable. And so that personal accountability is something that we really want to be aware of, something that the government has been serious about in recent years, of course. As a result, the personal liability of all home health and hospice agency owners, employees, and contractors has greatly increased. And we'll look at some of the crazy way that these costs can actually add up when it comes to liability. So you cannot expect to avoid personal liability by hiding behind your organization's settlement with DOJ and or the OIG. So we've seen that numerous times where there's a settlement, but it's not a clean slate. There's always a way that these government entities can get to you. We've called it death by 1,000 cuts previously. There's always another angle to be concerned about, and that's why you really have to have your bases covered in these audit situations. All right, so we'll go to the next slide now and look at some of these risk issues. We'll start out with risk issue number 1 here, Medicare Advantage and Medicaid managed care concerns. So a recent trend that we've been seeing is that CMS wants out of the direct administration of healthcare. So they're actively working to move all Medicare beneficiaries to an accountable care plan. And this was something they announced back in 2023, and this still holds true as well. So today, the Centers for Medicare and Medicaid Services announced that 3 innovative accountable care initiatives will grow and provide higher quality care to more than 13.2 million people with Medicare in 2023. You see there that more than 700,000 healthcare providers and organizations are going to participate in that. That has been the case, just as it was said. This growth further achieves the CMS's goal of having all people with traditional Medicare in an accountable care relationship with their healthcare provider by 2030. So we've still got about 4 years off of that guideline there, and it is continuing to trend that way. We're seeing CMS kind of move their way out of this sphere. And so we'll go to the next slide, Gio, and see some of the repercussions of that. So what does this mean? It means that you really got to review your appeal options before you enroll in a plan. That's something that simply must be done. You need to know your appeal options, what kind of rights you have. For example, several Louisiana providers participate in Medicaid managed care through Healthy Louisiana. As one general counsel recently wrote, we're a CDO and not a health care plan or payer. CDO is a care delivery organization, legal entity whose primary mission is the delivery of healthcare related products and services. And then you look at the effects of what kind of rights you have with an appeal. Well, here's one, a arbitration language saying that any controversy shall be settled exclusively by binding arbitration in Baton Rouge, Louisiana, by a single arbitrator pursuant to the American Health Lawyers Association's dispute resolution rules then in effect. And so that is going to be very important to know that, if there's a dispute, it's going to arbitration. And the provider, the healthcare, or the CDO in this case, is going to be very familiar with those rules of arbitration because they're taking all of these disputes there. So that can be an advantage to the CDO. Now, some CDOs also provide services to Medicare Advantage patients. When describing, for example, its relationship with WellMed, United Healthcare states that they are an affiliate of United Healthcare, manages administrative services for members enrolled in certain United Healthcare Medicare Advantage health plans in Louisiana. Next slide, please, Gio. So to break it down into some easy actions that need to be taken, read your contracts. And that's something that can apply not only to healthcare, but of course everywhere. We know that these are long, lengthy documents. It's not always clear. The legalese, as they put into there, it's not always clear what they mean. That's, again, another reason why, it's always good to have a healthcare attorney on your side when you're looking at these bulky documents. Your home health or hospice agency needs a copy of the contract. That's another thing. We've had many different occasions where a contract is not readily available. That takes time then to track it down. You've got to go through the grapevine and figure out where the contract's at. You never want that. You just want to have a copy available. So you know your obligations concerning coverage and billing. Know your deadlines, of course. That's always important. You could skip a deadline, miss it, and just be out of luck completely. So that's something to always be aware of. Understanding your appeal rights we talked about. Are you going to arbitration? Are you able to go into a court of law? That's something that's going to heavily affect your decision making. And then just know that every payer is different, of course. Understand the specific rules imposed by each payer. Really, when you get down to it, you've got to be looking at your contract with these payers, and that's what's going to dictate the events that occur in the event of a dispute or any other issue that may arise. Next slide, please, Gio. All right, so we get to risk issue number 2 now. This is going to be non-compete clauses in employment contracts and independent contractor agreements. So in April 23rd, 2024, the FTC issued a final rule in the Federal Register covering non-compete clauses. Now, we'll see that this final rule was not able to go into effect, but this is what it said. It imposed a comprehensive ban on new non-competes with all workers, including senior executives. For existing non-competes, the final rule adopted a different approach for senior executives than for other workers. For senior executives, existing non-competes can remain in force. Existing non-competes with workers other than senior executives are not enforceable after the effective date. So essentially, there were challenges to this rule throughout 2024, and then the current status is that they prevented the final rule from going into place on that target date of September 4th. And FTC has abandoned their efforts to get this final rule out. However, and this is why this is still a risk issue for 2026, they continue to focus on non-compete agreements through a case-by-case enforcement. And they are still trying to implement those factors up in red there that they tried to promulgate initially. Now it's just being done on a case-by-case basis. And so they're really getting down into the details with each of these cases. Trump administration, been going for about a year. We're going to see how this continues to impact this issue. And we'll go to the next slide and talk a little more about these non-compete clauses. So why should you care? Well, it gets back to those contracts that we were talking about earlier, that you always have to know what is in your contract. So check your employment contracts and your independent contractor agreements. Do you have an effective contract or agreement in place? This is something that you need to know. If you've got a faulty contract that's not going to have legal effect, then you've got to know that, because you won't be able to enforce it. Do these individuals qualify as independent contractors? That is an issue, employment law issue. We won't get too deep in the weeds on that. However, I will say that the general rule, very general rule, is that when you're looking to see if somebody qualifies as an employee or an independent contractor, typically you look to see how much control the employer exerts over the employee. Are they controlling their hours? Are they controlling the tools that they're doing their work with? Are they controlling their uniforms and such? Giving them procedural manuals? All of that makes it look more like a person is an employee than an independent contractor. So that's just something to be aware of. That's something that's been cracked down on. Sometimes a company will call a person an employee, but really, an independent contractor, but really they exert all this control over them and they're really an employee. So any other things to look at here are if the agreement includes non-compete language, we talked about that, the crackdown on that, non-disclosure of trade secrets and such. proprietary information, that's very common. Non-solicitation, we see a lot. Event of a breach, the rights and remedies, that's going to be in pretty much every contract. Definition of what constitutes as a material breach in order to terminate the contract. Venue for disputes, we looked at that with the arbitration earlier. Choice of law could be there as well. And then oftentimes you'll see some language that talks about gathering up attorney's fees and costs. Next slide, Gio. All right, so then we get over to risk issue number 3, which is HIPAA privacy issues, the Office of Civil Rights Enforcement efforts that have been made and ramping up, which has been a common thread thus far in the presentation, the crackdown on fraud. Since the compliance date of the privacy rule in April 2003, OCR has received over 370,000 HIPAA complaints, so it's getting up there. As of October 31st, 2024, OCR had settled or imposed civil money penalties that have resulted in assessments of over $140 million there. So that's only growing, and it is growing exponentially each year. So the amount of money, as I stated a bit earlier, can get quite astronomical in these cases. Now, OCR makes referrals to the DOJ for criminal investigation appropriate cases involving the knowing disclosure or obtaining of protected health information in violation of the rules. And we'll talk a little more about protected health information later in the presentation. To date, OCR made 2,419 such referrals to the DOJ. So OCR is making referrals. It's something to be aware of, certainly. Now, HIPAA compliance issues alleged in complaints include, and this is in order of frequency, and we see these all the time, impermissible uses and disclosures of PHI. We talked briefly about PHI. We'll continue with that conversation later, and that's the name of the game, is protecting that PHI. Lack of safeguards, of course, of PHI. Lack of patient access to their protected health information. That's something that'll be coming up later as well. Patient access is very important. Transparency and getting those records to the patients when they want. Lack of administrative safeguards of ePHI, of course, is coming up as well. And with the rise of artificial intelligence, I'm sure there will be, even more issues with plugging in health information into AI models. And then use of disclosure of more than minimum necessary PHI. So if you have to disclose for any reason, and it is a valid reason to do so, you want it to be the minimum necessary there. You don't want to be just willy-nilly throwing PHI around there. All right, next slide, Gio. Right to access patient records here. This is a big one. So November 2024, the civil monetary penalty, they can get up there, $100,000 collected against mental health care provider. Was the result of an investigation where the provider actually failed to provide patients with timely access to their medical records. So HIPAA's privacy rules, right of access provisions, require that individuals or their personal representatives have timely access, as we talked about, and that's going to be within 30 days, with one possibility of a 30-day extension, and for a reasonable cost-based fee. So, you've got 30 days, but you've got to get it to the patient, or you're going to get slapped with that CMP, which we see there is $100,000, and that can certainly add up based on how many patients are requesting that their PHI or their medical records in general. That was the 51st right to access case brought to by OCR, and we fully expect to see more of those. And then lack of safeguards of protected health information, something, again, that's going to be very relevant with the rise of these new artificial intelligence tools that give us much information, but also, we've got to make sure that there are safeguards in place. So OCR initiated an investigation of a Washington State hospital following the receipt of a breach notification report stating that 23 security guards working in the hospital's emergency department used their login credentials to access patient medical records maintained in the hospital's EMR systems without a job-related purpose. So this is cracking down even to just logins by security guards. So the information accessed had names, date of birth, medical record numbers, all this information about the patients, and not even clear that the security guards went in to get that information. Simply, the information was available at the location the security guards entered. So to resolve these allegations, the hospital agreed to pay $240,000 and implement a plan to update its policies and procedures to safeguard protected health information and train its workforce members to prevent this type of snooping behavior in the future. So again, we see the high costs that this hospital had to pay, $240,000, and then it's not cheap either to implement a plan consistently and continuously to make sure that this doesn't happen again. But to be honest, retroactively having a plan of that nature is one of the best things that you can do if one of these audits cracks down on you. You can say, we've been doing our due diligence so that this does not happen. And so that's something we see a lot, is these plans and policies and procedures to safeguard all this information. Those get put into place. Next slide, please, Gio. All right, now this is another big one where the fees add up, the penalties add up quite quickly. We'll look at some of the numbers. False Claims Act liability of home health and hospice agencies and owners. And these enforcement efforts are accelerating post-COVID. So settlements and judgments from civil cases involving fraud and false claims against the government exceeded $2.9 billion in fiscal year 2024. We didn't have the 25 numbers available to us yet, but this is last year, and we see those numbers skyrocketing every year. Of this amount, more than $1.67 billion is attributable to healthcare-related cases and matters. Now, during 2024, there were 979 whistleblower cases filed, and we're seeing that a lot. That can result in extreme payments. A record over 1,200 new False Claim Act cases were initiated in 2023. And that was the first time that more than 1,000 new False Claims Act cases have been filed in a single year. Fully expect that to continue as these whistleblower cases are on the rise as well. A lot of times those are the False Claims Act cases. Now, during 2024, DOJ and whistleblowers were a party to 588 settlements and judgments, the highest number in a single year. So again, we see that settlement. As we talked about too, it's not just the settlement. It's not just that final number that you settle for. There's other ways that these governmental entities can get at you. There's other costs that are going to accumulate. Putting in those safeguard procedures, that's something that your practice is going to have to do for years to come as a result of these audits. And so, that number there is huge, the 2.9 billion, but that's not even the totality of the costs that can stem from these issues. So we'll go to the next slide now, Gio. And now we'll talk a little bit about risk issue number 5. So the expansion of billing revocation actions, expansion prior to the 2019 expansion, the revocation reasons that may be cited by CMS included the following 2022 reasons, and we won't go into all of those reasons right now. We'll just highlight some of the main ones there. Felonies is one. False or misleading information. That's something that comes up quite a bit. Abuse of billing privileges is one that is very common. Auditors are not supposed to revoke for small audits on the basis that there's an abuse of billing privileges. It's supposed to be a continuous and sustainable abuse by these providers. However, it's certainly been the case that contractors, MACs, are revoking for just one little audit. So abusive billing privileges is certainly one to highlight there. Improper prescribing practices, of course. There's another one. Debt referred to the United States Department of Treasury. A lot of times when we see these audits, it's pretty much automatic that they're going to refer the debt to the United States Treasury if it is unpaid for the specified amount of time on the demand letter that they send. And so that is one that we see quite a bit as well, that Treasury issue. Patient harm, of course, one down there that is taken very seriously. So these are an expanding list of reasons why you can get revoked. So we'll go to the next slide, talk a little more about that. And we'll go a little more in depth here. So there was an additional revocation authorities that were added. Non-compliance revocation ground here. CMS modified the existing regulation so that now several other enrollment requirements must be met. CMS has expanded the language to include all enrollment requirements regardless of their placement in Title 42. So all of these requirements need to be met. That's very strict. Misdemeanor convictions, so a little less than those felonies there. CMS can revoke a provider's or supplier's enrollment if they or any owner, managing employee or organization, officer or director thereof, have been convicted. You see how broad that is, by the way. Have been convicted of a misdemeanor under federal or state law within the previous 10 years. So they're going back a decade to see these misdemeanors that CMS deems detrimental to the best interests of the Medicare program and its beneficiaries. And the key word is CMS deems, so they've got the authority to make that call, and they certainly will. So that's misdemeanor convictions. False Claims Act civil judgments. So CMS can now revoke enrollment. Again, that broad language, provider, supplier, managing employee, owner, everyone pretty much. If there's been a civil judgment under the FCA imposed against them within the previous 10 years. So that's another. We talked about the FCA earlier and how it's not just that settlement amount. It's not just what you agree to pay. They can still tack you with these revocations, which can be extremely harmful as well. Violation of provider and supplier standards, got to keep those in mind. And then there's that debt referred to the U.S. Department of Treasury. So this is one where they added language. The the revocation can be made when the provider's or supplier's Medicare debt has been discharged by a bankruptcy court, these are exclusions, and these are very narrow and tough to hit. So it's not always great to rely on exclusions. Or the administrative appeals process concerning the debt has not been exhausted, or the timeline for filing such an appeal at the appropriate appeal level has not been expired. And that, goes back to that timeliness, knowing your deadlines, because when an appeal needs to be made, you've got to get it in by the deadline, or you're going to be out of luck, and you're not going to meet this exclusion. You're not going to be able to get further appeal on those claims. And that, again, highlights the reason to hire a healthcare attorney. Just have somebody who knows these rules and can assist you through these processes. And we will go now to the next slide, Gio. All right, so we've got risk issue number 6, and I'm going to pass it off now to Lester, who is going to talk to you about a few criminal cases here.
All right, so again, like Michael said, we're going to talk about some of the criminal cases that have occurred recently. First one, Eastern District of Louisiana, owner of a hospice pled guilty to role in the payment of illegal kickbacks to several individuals. This is a real easy way to get in trouble. And way back in the day, most like regular healthcare fraud cases almost always involve some element of a kickback or stock law, anything else. It's something other than violation of coverage rules. Never ever pay a kickback. All your contracts with referral sources need to be looked at by a qualified healthcare attorney. It's easy for us to paper these things up and make them legal. your say medical director agreements and things like that. So there's just really no excuse for violating it. Not most of the time with the home health. Sometimes they can get complicated to structure things, but it's fairly simple in y'all's area of healthcare. Another Eastern District Louisiana case, New Orleans man pleaded guilty to his role in a scheme to solicit the payment of illegal healthcare kickbacks from several individuals. They got 2 psychiatrists who were paid $1,500 a month for the referral of patients for medically unnecessary home health services, and $331,000 in kickbacks for a patient recruiter that are disguised as marketing fees. So when you're dealing with marketing employees, you want to make sure that they're actual employees. You can structure sometimes something with an independent contractor, but if they're getting paid anything that varies in any way based on the volume or value of referrals or other business they generate for you, which obviously makes sense for marketing employees, you really want them to be a W-2 employee because the safe harbor under the anti-kickback statute is much simpler and easier to comply with than the safe harbor that's for like independent contractor services. The exact same tasks being done in one situation, it can be easily safe harbored in the other. When they're not an employee, it's much, much harder. Okay, so Louisiana psychiatrists referred patients for medically unnecessary home health services in exchange for $1,500 a month. Payments were made to the psychiatrists for disguised as kickback payments from the home health, likely in the form of a medical director agreement or other consulting agreement. You want to make sure that all your medical directors are paid, in accordance with the work that they're actually doing. In different settings, that means different things. Sometimes with a hospice, it can be a little bit more involved. And so sometimes their medical directorship agreements are a little higher than, say, a nursing home's medical director. It depends on how much work it really takes the medical director to do their job. Lots of little, a drug rehab or a hospice where the medical director actually has to see patients a lot, they're obviously going to pay them more. So it's all got to be fair market value. That's the key there. So let's go to the next slide. All right. So this was a psychiatrist given 4 years probation in order to pay restitution. Alleged she referred psychiatric patients for medically unnecessary home health services. This, again, $1,500 a month. So they're just basically looking at the patients that were sent over, and apparently the psychiatrist was sending a ton of patients to home health, which is probably pretty weird, but in the end, she was receiving kickbacks and wasn't actually doing work. So that's how they get popped. So in another case, the owner of home health was he was a physician served as medical director, convicted of 1 count of conspiracy to commit healthcare fraud and one count of healthcare fraud. They alleged that the medical director falsely claimed that a number of beneficiaries were qualified for home health services. Owner was sentenced to 96 months in prison, and the medical director 72 months. Really just showing you the length of sentences here. They can get pretty lengthy, and it can all just be based on whether or not they actually qualify for the benefit. You want to make sure that's all your referral documents are clear in the, say, terminal need, terminal illness for hospice, or with home health with the other requirements for that. And you've just really got to stay on top of that. The justification for the care has got to be there. It's got to be documented clearly. So another patient recruiter situation, the office manager was popped this time, assisted with the payment of illegal kickbacks to patient recruiters and submitted claims to Medicare for falsely stating that patients were homebound and received services. So, all of your people can get hit. You can have your medical directors, your owners, your administrators, medical directors, or office managers even. So everyone can get in trouble for this. It depends, obviously on what each person did. But especially if you're just an employee of a home health or a hospice, don't commit fraud to cover up mistakes that you made or to try to keep the business afloat. It's not worth it. Your freedom is worth much more than any kind of money. Let's go to the next slide. So June 2024, owner of a Louisiana based hospice was sentenced to 72 months in prison in order to pay $3.6 million in restitution to the government. From 2009 to 17, they had allegedly placed 24 patients on hospice despite the fact that had not been diagnosed with a terminal condition. As a result, defendant was charged and convicted with conspiracy to commit healthcare fraud and 3 counts of healthcare fraud. So this is basically just a situation where they got a really long sentence, 72 months. That's not nothing, and 3.6 million restitution, and they just didn't have it in the documents to support the original, terminal diagnosis. They just simply weren't. And another one in May 2024, I actually know a lot about this case. Owner of a Louisiana-based hospice was convicted of healthcare fraud, alleging overbilling, and sentenced to 240 months in prison. Really long sentence. Defendant was ordered to pay $42 million in restitution for defrauding Medicare. The defendant allegedly billed a number of beneficiaries at the general inpatient level of care when this level was not supported by the needs of the patient. Additionally, the government alleged that a number of patients were ineligible for hospice. This is a unique case in the sense that it involves no kickbacks or anything like that. It's basically just based on the documentation for the care provided, and I think a lot of patients were on the general inpatient for a long time. One really strange situation about this case, it's not really what the charges were based on, but the government alleges that, this is what popped up and caught my attention. They allege that all physician services are included in the hospice per diem, which is not true, but they said it a ton in the cases and all their briefs, and I'm really not sure what they were getting at, because it's just administrative services like medical directorship, attending team meetings, interdisciplinary team conferences, things like that are included in the per diem, not actual medically necessary patient visits. But they alleged it anyway, and that's a big chunk of what the 42 million is based on. But the basic problem here is having patients on general inpatient care for a long time, and they weren't really receiving much care while they were in there. Brief visits, things like that. And in a related case, a registered nurse who served as administrator of one of those hospices pled guilty to conspiracy to alter or falsify medical records in connection with a federal audit. Government alleged the hospice was audited by Medicare, and defendant altered, amended, or falsified medical records to justify the hospice services billed. What this is a situation where they got an audit, and there was a lot of, I guess, technical non-compliance, dates not on forms, things like that. And I guess technically maybe the administrator felt responsible for that as the administrator of the hospice and tried to kind of cover it up and basically just falsify, put dates on records that didn't have them and things like that. There's the sad thing about this case is, had they documented things properly, that'd have been fine. This lady wouldn't have been charged. She would have had no need to alter any records. A lot of the patients could have qualified had they had the right dates in the right places and things like that, but they just didn't. Sorry about this. I know y'all can hear a train coming behind my house. So let's go to the next slide. But in the end, do not alter record. Do not commit fraud for your employer. It's dumb. You end up getting in trouble. They end up getting all kinds of leverage over you, and it's really just not worth it. It's someone else's business. Don't commit fraud for your employer. Not even to cover up your own failings. I mean, just if you made a mistake and it cost the company money, you're just going to have to eat it. Don't try to do anything heroic or dumb to prevent, say, an overpayment from occurring. So administrative audits. So a special focus program. This shows up in nursing homes and other provider types as well. It's usually just with like your survey compliance, so more of your conditions of participation than actual claims audits. But special focus program audits have been designed to monitor hospices that are identified as poor performers based on certain quality indicators. So anytime you're selected under this audit program, you've got additional surveys and stuff that happen, and you've got more, a lot more of those. And I guess there's more penalties that can be added on. You have denial of new admissions and things like that. If hospice agencies are unable to resolve the deficiencies that led to the review, they can be terminated from participation. But there's a lot of different alternative enforcement remedies they can use to get them back on track. It's not the end of the world, but it's not something you want to be part of. Hospice provisional period of enhanced oversight audits. So this deals with basically CMS just noticed that there was actually an uptick in fraud, and there were a ton more newly enrolled hospices in Arizona, California, Nevada, and Texas. So they started requiring, I guess, a period of enhanced oversight for new hospices in the area. Reasons for PPEO primary denial reasons are documentation submitted doesn't support the prognosis of 6 months or less, physician narrative not present or not valid, hospice selection statement doesn't meet statutory regulatory requirements, no certification for dates billed, and the hospice continuing care hours reductions. So basically they'd be auditing your claims, things like that, but it's just, this is for new enrollments. And they're just basically trying to see if there's a bunch of, I guess, fraudulent providers coming online and starting to build a program. Let's go to the next slide. TPE audits. Here y'all all dealt with these before. The TPE audits are serious. They're, if you're subjected to one and you fail to achieve an acceptable level of performance, they'll refer you to CMS for possible additional action. What's going to end up happening is 100% prepayment review. Almost always the case. But it's also likely a referral to the appropriate UPIC to be made, and postponement audits can also be conducted. This is something you see across the board, and not just Medicare audits, not just Medicaid audits. Once one auditor comes in and sees you as a ripe candidate for denials, they'll keep on auditing you because they figure you're not going to change anything. So when you do, if you do ever have a bad audit and you have up, say, $125,000 or whatever overpayment, you have to make sure you fix all of those problems so that if you do get audited again, at the very least, the reasons for denial are different. You want to, everyone's expected to kind of make mistakes here and there and have compliance issues pop up. What the most important thing is how you respond to them. So what did you do in response to this letter saying that you had a bunch of denials or whatever? You may disagree with some of them. You may think that, I should appeal this, but, they still made a good point that you didn't document well. Maybe you documented well enough to get paid, but at least, they had a good point in their denial. So sometimes even if you're appealing, you still want to fix the problems they raised. So, TPE primary denial reasons are eligibility not documented, missing face-to-face, incomplete certifications or research, or maybe the timeliness of them are off. Go to the next slide. Now, TPEs aren't the end of the world, but if you're not a good provider, they can be a real headache. Next slide. So cert testing. All right, comprehensive error rate testing, audits of hospice claims. So this is basically just to kind of audit. They're not so much auditing the providers directly, they're auditing the payers, making sure that they're only paying claims that are valid claims. But it results in them auditing you, obviously. So, they looked at back in 2024. They did a SART audit looking at hospice claims, looked at both hospital and non-hospital based services. The projected improper payment amount for the hospice services was 1.8, resulting in 1.8 billion, resulting in an improper payment rate of 7.1%. Notably, this was up from an improper rate of 5.4% during 2023 period. So basically, they're just looking at overall the claims, like how the claim audit process works and how well it's preventing additional new overpayments. So it's just basically, it's not a whole lot different from the rest of the claims, but they're more auditing the payers and the audit process than they are auditing you, although it is your claims that do in fact get audited. But it's more to make sure that the rest of the audit process is working. Let's go to the next slide. All right, supplemental medical review contractor audits. There's so many auditors. I mean, this is ridiculous. Recent years, Noridian has conducted reviews of general inpatient care level of care for hospice services to determine whether the proper level of care is being billed. As you know, there's general inpatient care, and there's respite care, and there's continuous home care, and then there's the general outpatient care in hospice. And so these are basically just looking to see if you've got the proper level of care, if they should be on respite instead of inpatient, if they should be outpatient instead of inpatient, things like that. As they always do, they always find, lots of times they find the beneficiaries not suffering from uncontrollable pain, didn't have unmanaged symptoms. So that's basically requirements for inpatient level of care. They may also find that, this is really, they're just using, say, the inpatient, service when really they should have been on respite, and I guess more or less just taking them in order to give their primary caregivers a rest. But lack of medical necessity, no response to documentation requests or certification deficiencies, just like all the other audits, are usually where you have problems. So if you do bad in a SNR C audit, the negative results of the audit can be used as justification cited by CMS when placing the provider on suspension or proposing that their enrollment be revoked. So it's just another kind of audit looking at this time a specific kind of issue, just level of care determinations, but it ends up, that's also what all the other audits audit, right? So it's kind of frustrating sometimes when you've got 12 different kinds of contractors who may be sending you a letter and auditing your claims, but that's the world we live in. So it's what it is. Go to the next slide. All right, so you pick audits. So these are the main one, the main fraud auditors, I guess. They're just constantly all the time pulling samples and conducting new audits. So although administrative, their primary purpose is to detect, deter, and prevent fraud, waste, and abuse in Medicare and Medicaid programs. Each contractor is responsible for handling federal program integrity audits of both Medicare and Medicaid claims within a specified area. So that there's little districts where they are. These people make a ton of money, like $100-something million for a year of audits. Frankly, they're printing money. We need to get some kind of way to replace some of these auditors. There's just too many, and they make too much money. But there's a lot of money in what they do. Obviously, there's billions of dollars billed to Medicare and Medicaid. So I guess there's a lot of auditors. So the primary denial reasons are eligibility deficiencies, just like the rest. Lack of consent to elect a hospice benefit. Sorry about that. Billing for higher level of care than medically necessary, and billing for hospice care provided by unqualified or unlicensed people. All right, let's go to the next slide. Kickback violations. We talked about this a little bit earlier. Anti-kickback statutes, criminal statutes, that makes it a crime to knowingly and willfully solicit, receive, offer, or pay any remuneration in return for referring an individual or arranging for the services payable by any federal or state healthcare program, or purchasing, leasing, ordering, or arranging for any goods, facilities, or services may be paid for in whole or in part by any federal or state healthcare program. So this catches both sides of the arrangement. It's basically just a kickback or bribe statute. It doesn't want you providing anything of any value whatsoever to a referral source in return for referring the patient to the program. So it's an intent-based statute, but you don't need to have the actual intent of this particular statute or the anti-kickback statute in particular. All you have to do is have the general intent to do what you're doing, which almost most people have. So basically, when they change, it used to you had to have specific intent to violate the law, but now it's much simpler. And basically, you just had to intend to pay the bribe or whatever it is. You didn't have to necessarily intend for it to be, just for referring or arranging purchasing of federal healthcare program services. If any purpose of it is that, then you can be convicted. Let's go to the next slide. But anti-kickback statute applies to a ton of services that are commonplace and perfectly legal. So in the end, this is something everyone has to deal with. It sounds scary, but it's not that big of a deal because it applies to so many contracts. I mean, literally every contract between a hospital and a physician has been reviewed for anti-kickback compliance. So obviously, we can contract with people without a problem. We just have to comply with the rules. The failure to comply with the rules is up to 10 years in prison, fine $100,000, exclusion from participation in federal and state healthcare programs, civil monetary penalties up to $50,000 per violation. And I'm telling you, there's a dozen other things they can charge you with. This is just one law. So they can really stack on penalties and stack on charges if they want, if you violated this law. So for instance, it's a False Claims Act violation to file a claim after you've violated the anti-kickback statute. So there's more things they can charge you with, but there's plenty of ammo in the anti-kickback statute itself. Most courts have adopted expansive reading of the knowing and willful standard. And again, like I mentioned earlier, the Third Circuit adopted a one-purpose test. They said if the payments were intended to induce their physician to use, in this case, CardioMed services, the statute was violated, even if the payments were also intended to compensate for professional services. So even if you really did need a medical director, if you only contracted with this medical director and only paid him the amount you're paying him now because he's referring patients to you, that can be a violation. You just really have to get a lawyer to look at these. the safe harbors can be really complicated, and it's hard to, you can't just read them and use plain language, I guess, interpretation to kind of know what's going on. There's a lot of sub-regulatory guidance that helps inform what, inform us about the, I guess, definitions of the various terms in the Act. And so it's not the end of the world, but it's something that you do not want to do with someone who's not qualified. You don't want to structure any contracts without someone who does actual healthcare law, not just a random corporate lawyer. Let's go to the next slide. Safe harbors. So like I said, anti-kickback statute applies to, and potentially applies to, tons of completely appropriate and legitimate business arrangements, right? So in recognition of this, Congress authorized the HHS, OIG to issue safe harbors for certain business arrangements and practices that, while potentially a violation of the law, would be permitted as long as certain safeguards are put in place to prevent fraud and abuse. So they're voluntary, not mandatory. So if you can't comply with every single element of a safe harbor, that's not the end of the world. It doesn't mean you violated the law. It just means you're not protected from, the possibility of scrutiny, I guess. So if you're safe harbored, you are in a safe harbor, and no one will question your arrangement. But if you fail to meet any one of those, all you've really lost is the safe harbor protection. It doesn't necessarily mean that you violated the anti-kickback statute. So lots of times we structure something where we know ahead of time, we cannot do it in a way that complies perfectly with the safe harbor. So what we'll do in those cases is we'll build in additional safeguards that are not even required by the safe harbors, but kind of attack or address the same kind of issues as the safe harbor rules, and we'll build those into the contract as just an additional safeguard protection. Currently, there's 11 statutory safe harbors and 36 regulatory ones. There's also a few exceptions, but we'll get into that another day. Let's go to the next slide. So most likely safe harbors to arise in home health are going to be the personal services and management contract safe harbor, which is essentially it's just a independent contractor arrangement with anyone who's not an employee but who's providing services for you, and employment safe harbor. So that just means for W-2 employees. So each of these safe harbors are the employment one's not that complicated, but the personal services one is very complex and typically requires legal assessment to determine whether it qualifies. Physician home ownership of home health or hospice agencies may be protected under the small entity safe harbor, but compliance is complex and meeting every element of that safe harbor is generally impossible. So this is an important thing to note about anti-kickback statute. It applies to not only, say, any salary or something that some, say, owner would have would get from a home health that they own, but also their profits. So, it's not just compensation arrangements, it's also ownership and profits that I guess can be the remuneration that leads to impermissible referral. So you got to look not just at the contracts between, say, the referring sources and the agency, but also, if they're an owner, their ownership. And so there is a safe harbor for investments in small entities. Again, you may not be able to comply with all of those elements, but we would get you to comply with as many as possible and then build in some additional safe harbors if you couldn't perfectly comply. Let's go to the next one. Now, the home health is a related law that applies to it called Stark law that severely complicates things there. That doesn't apply to hospice, but again, there's a ton of different laws that apply to y'all. Just contact a healthcare lawyer before you do any major contracts. But let's see. In December 21, they made changes to the personal services and management contracts and outcome-based payments regulation. Under the final rule, prior to the issuance of the final rule, in order for personal services and management contracts to qualify for coverage under the safe harbor, the aggregate compensation had to be set in advance. This is one of those elements that made it impossible for a lot of things to qualify. So if you had indeterminate kind of hourly compensation, like $50 an hour for however many hours you work this month, that would be impossible to safe harbor because we couldn't put in the original contract all of the compensation that will ever be paid. And obviously that's not that big of a fraud issue. So what they did when they modified the rule was they made it mirror the Stark law. Again, it's a separate little law. It also deals with referrals. They made it mirror its related, I guess, provision. There's exceptions to Stark law, and it had a provision in one of the ones for independent contractors that said that if the aggregate compensation wasn't set in advance, then the method for determining compensation could be set in advance, and that would satisfy, I guess, Stark law. So now that's the same rule applies to a kickback, which is a much more useful way of writing the rule. Still accomplishes the same thing, but it doesn't make us fail to meet safe harbor, protection for something as silly as not being able to put the total amount of compensation paid over the entire amount of the agreement, in writing in the contract itself. So they also changed where our remuneration doesn't include payments made by a principal to an agent as compensation for the agent as long as the following standards are met. So here's the basic personal services management safe harbor. It's got to be in writing, signed by the parties. It's got to cover all the services the agent provides to the principal for the term of the contract and specifies the services to be provided by the agent. So it can't just say provide physician services. Like it's got to be more specific than that, all the things that they're doing. The term of the agreement is not less than 1 year. The methodology for determining compensation paid to the agent is set in advance. So again, this isn't the total aggregate compensation set in advance. This is the methodology. So this is a new rule. Set in advance, consistent with fair market value in an arm's length transaction, and not determined in a manner that takes into account the volume or value of any referrals or the business generated by the parties for which payment may be made by Medicare, Medicaid, or other healthcare programs. The services performed in the agreement do not involve the counseling or promotion of business arrangement that violates state or federal law, and the aggregate services contracted for do not exceed those that are reasonably necessary to accomplish commercially reasonable business purpose of their services. This is one that people trip up on a lot. They'll end up doing, this is basically if you need, I don't know, 3 hours worth of services a week, but you buy 30 from someone, that's more than is reasonably necessary to accomplish the business purpose of the arrangement. So that would be a situation where the aggregate services were too much, even though there were fair market values set in advance and all those other things. Let's go to the next slide. Starting to run out of time, guys. Employment safe harbor. Again, I told you earlier, this one's simpler. It's bona fide employment safe harbor states that there's no violation of the statute for any payment by an employer to an employee for employment in the provision of covered items and services. So it's any amount, basically. There's no fair market value requirement. There's nothing really. It's just got to be a bona fide employment relationship for employment in the provision of covered items and services. If you're employing them to do commercials, that's different. But as long as the agreement is for providing services, then you're good. So it's an affirmative defense on which the defendants have the burden of proof, though. So you've got to prove that they are an employee. But the Fifth Circuit found that they adopts the basic tax law definition of employee. So incorporates the general common law of the agency rather than the law of any particular state. So it's about the hiring party's right to control the manner and means by which the work is done, the hours, location, things like that, who owns the equipment. Let's go to the next slide. All right, so recent kickback areas. Be careful entering any business arrangement with an individual entity that has a business ability to refer business to you. That's always your main thing. Anyone who orders anything for you, you got to be careful when you're contracting with them. If they refer people to you either because they're a doctor or they're a discharge planner, before you enter into an agreement with them, you need to have a lawyer help you. Continuing concern is lease arrangements with actual or potential referral sources. You may lease, it's just like with the aggregate services contracted for requirement. If you lease far more space than is necessary from, say, a referral source just to give them a ton of money, that would be a violation. So engage or employing a medical director who makes referrals to your hospice or home health is a common area, obviously, but tons of times it happens and it can be perfectly legal. Also, having too many medical directors can raise your risk and increase scrutiny. If you do have multiple medical directors, I always want them to I want their pay to be cut based on that because they're a division of responsibilities, and I want them to have completely different areas of responsibility in the organization, not the same job, essentially. Dine and dash approach, so lunch and stuff like that given to referral sources, sham loans, gifts, things like that, giving any kind of type of remuneration, gift cards, sporting events, stuff like that. You can even give that to a patient. That can violate the beneficiary inducement statute. So gifting things to referral sources or patients can both be harmful or illegal. Let's go to the next slide. I think we are now about medical director agreements. Basically, this would either fall within the independent contractor or the employment arrangement one. But obviously, this is a big risk area for everyone because if you pay your medical director too much, obviously it may be a payment for a referral. So that's basically all this is saying. We kind of discussed this already. Next slide. Fair to screen for individuals. Before you hire anyone, you got to screen them against the OIG exclusion database, and technically in every state, but there's state and federal ones. So just make sure that you're screening everyone and doing the right background checks. And I think is that it? That must be. No, not the last one. Sorry, everyone. I'm really slow today. The primary concern about excluded individuals is approximately 44% of exclusions related to licensing issues as the main reason, and 50% of the cases exclusions are based on felonies. Lots of times it has to do with someone getting convicted and then they immediately get thrown on the list. Sometimes people don't show up on the list. There's nothing you can really do about that. You're not expected to be able to discover every possible excludable person, but you definitely have to know that they're not on the exclusion database currently. So if you got them working for you, you can't get paid. So no matter how much you like them, you got to get rid of them if you got anyone who's excluded. Next slide. This is just some examples of the same kind of thing where it shows you how costly a failure to screen for excluded individuals can be. Just several examples, and that's it.
So far we don't have any questions. I think we're just gonna close it out. So thank you so much to our presenters, Michael and Lester, for that information, and thank you to our attendees for joining us today. I'll be sending a copy of the PowerPoint slides tomorrow, and if you have any other further questions, please reach out to Michael and Lester. Their emails are above, or you can contact us directly. And have a good Tuesday and Happy New Year's.
Yeah, Happy New Year, everyone.
All right. Thanks, everyone. See you.